connecting contract law to what you already know. In earlier chapters, you learned how land is described, who owns it, and how rights are transferred. Legal descriptions, survey systems, and land management all answer one big question. What exactly is the property? Contract law answers the next essential question. What exactly are the parties agreeing to do? Every real estate transaction you will ever handle, listing a home, writing an offer, drafting an amendment, creating a lease, or negotiating an option, is built on contract law. If the contract is not valid and enforceable, everything else you do in the transaction is on shaky ground. This section introduces the basic concepts of contract validity and enforceability that apply nationally and that underlie all real estate contracts, whether they involve a studio condo in the city or a large ranch in the countryside. Real estate contracts in everyday practice. Real estate contracts are the legal agreements that make the business work. A purchase and sale agreement moves ownership of property from seller to buyer. A lease transfers the right to use and occupy, but not own a property. An option agreement gives a buyer the right, but not the obligation, to purchase at a later date. Mortgage documents and promissory notes govern the financing of a purchase. Listing agreements and buyer representation agreements define the relationship between client and broker and set out how commissions will be paid. Even a simple counteroffer form is part of the contract framework. All of these documents are built on general contract principles: offer, acceptance, consideration, capacity, and lawful purpose. Once you understand what makes a contract valid, void, voidable, or unenforceable, you can better recognize where problems may arise and when to recommend legal advice. What is a contract? Meeting of the minds. A contract is fundamentally an agreement between two or more parties who reach a meeting of the minds on specific terms. This means they clearly understand and agree on what is being offered, what is being accepted, and what each party promises to do or not do. The contract is not the paper itself. The paper is merely evidence of the underlying agreement. A valid contract is legally enforceable because it meets certain requirements set by contract law. If those requirements are missing, the agreement may be invalid, void, voidable, or valid, but unenforceable. In real estate, this meeting of the minds typically appears as a written offer signed by a buyer and then signed in acceptance by a seller, or as a listing agreement signed by both broker and seller. When the parties sign, they are expressing their intention to be bound by the terms they understand. The legal status of contracts: valid, void, voidable, and unenforceable. Courts classify contracts into 4 basic categories when determining legal status. A valid contract contains all the essential elements required by law and is binding and enforceable. For example, a properly drafted written purchase contract for a 3-bedroom home, signed by competent buyer and seller with clear price, closing date, and property description, is valid if all required elements are present. A void contract is one that never met the legal requirements for a contract. It is missing an essential element, such as lawful purpose or consideration. So no contract was ever created in the eyes of the law. A contract to sell stolen property or a contract with no consideration at all is void. A voidable contract is one that appears valid on its face, but can be rescinded by one party due to some legal disability or problem that affected consent, such as fraud, duress, undue influence, mistake, or lack of capacity. Only the injured or protected party has the right to disaffirm. A real estate example would be a contract signed by a buyer who is misled about a material fact. The buyer may choose to rescind the contract once the truth is discovered, but the contract remains valid unless and until the buyer exercises that right. An unenforceable contract is one that may be valid in theory, but cannot be enforced in court. This usually occurs because a law, such as the Statute of Frauds, requires that particular contracts, including most real estate contracts, must be in writing. An oral long-term lease or an oral agreement to sell real estate might satisfy all the elements of an agreement. But if a statute requires that such agreements be written, a court will generally refuse to enforce them. The contract may still be performed voluntarily, but the parties cannot rely on the courts to enforce performance. Valid contracts. All essential elements present. A valid contract meets all legal requirements. While wording and format may vary, certain elements must always be present. First, there must be a clear and definite offer that spells out exactly what is being proposed. In real estate, this means a buyer's written offer identifying the property, price, closing date, and major terms. Second, there must be an intentional, unqualified acceptance of that offer. The seller must agree to the terms without changing them, usually by signing the offer or a clean counteroffer. Third, there must be consideration, which is something of value exchanged between the parties. Consideration is often money, such as earnest money and purchase funds, but it can also be a promise to perform or to refrain from acting. Fourth, the parties must have capacity. They must be of legal age, mentally competent, and properly authorized to act. Fifth, the parties must intend to create a binding agreement. The context must show they are making serious legal promises, not joking or speaking hypothetically. Finally, the object or purpose of the contract must be lawful. A contract cannot be used to carry out an illegal act or violate public policy. Imagine a buyer offers to purchase a home for a specified price. The seller accepts in writing. Consideration is provided in the form of earnest money and the promise to pay the purchase price. Both parties are adults of sound mind, and the purpose of the contract is the lawful transfer of real estate. In that case, assuming no other legal defects, the contract is valid. If any of these elements is missing, problems arise. Void contracts. Missing an essential element. A void contract lacks one or more essential elements and is therefore not a contract at all. Neither party can enforce a void agreement. For example, suppose a contract proposes to transfer a property that the seller does not own and has no right to sell. The object of the contract is illegal because a person cannot convey title to property they do not own. Similarly, a contract with no consideration, such as an agreement where only one party promises to do something and the other provides nothing in exchange, fails the consideration requirement and is void. In practice, a void agreement does not need to be formally terminated. Since no valid contract ever existed, both parties are free to walk away. Valid but unenforceable contracts. Valid but unenforceable contracts appear to satisfy all the elements of a contract, but cannot be enforced due to specific laws. The statute of frauds, which requires that transactions involving real estate interests be in writing, is the most common source of unenforceability. An oral agreement to sell a house or an oral lease for more than 1 year may be valid in the sense that the parties truly agreed. But if one party refuses to perform and the other party sues, the court will likely decline to enforce the agreement because it was not reduced to writing. However, if the parties voluntarily perform the contract, the outcome will generally stand. For example, if an owner orally agrees to lease a building for 3 years, the tenant moves in, pays rent, and the landlord accepts those payments, then both parties have effectively executed the contract. At that point, neither can use the statute of frauds to undo what has already been performed. Voidable contracts and the right to rescind. A voidable contract starts out looking valid, but is subject to rescission by one party, because that party's consent was affected by a legal problem. Typical grounds include fraud, misrepresentation, duress, undue influence, mistake, or lack of capacity at the time of signing. Only the injured or protected party can choose to make the contract void by disaffirming it within the legal timeframe. For instance, if a seller induces a buyer to sign a purchase contract by falsely stating that the roof is brand new when it is actually 20 years old and leaking, and the buyer can prove this misrepresentation, the buyer may rescind the contract. If the buyer decides to go forward, however, the contract remains valid and can no longer be treated as voidable once the buyer has ratified it through performance. Real estate also provides examples involving capacity. A contract signed by a minor or a person temporarily incapacitated by intoxication may be voidable by that person once they regain full capacity, depending on state law. If they choose not to rescind and instead accept the benefits of the contract after regaining capacity, the contract may be considered ratified and fully valid. Unenforceable contracts and the doctrine of laches. Some contracts are simply unenforceable because their terms are too vague, incomplete, or confusing to allow a court to determine what the parties promised. Others may be unenforceable because the injured party waited too long to assert their rights. The doctrine of laches and statutes of limitations both relate to the timing of enforcement. If a buyer believes a seller breached a contract but waits many years to file a claim, the law may bar the action. The statute of limitations sets a time period within which legal actions must be brought. The doctrine of laches focuses on unreasonable delay and prejudice to the other party. In practical terms, if one party sits on their rights and allows evidence to become stale or circumstances to change significantly, a court may refuse to enforce what might otherwise have been a valid claim. Essential elements of contract validity. To be valid, a contract must satisfy certain criteria. Competent parties are essential. The parties must be of legal age, mentally competent, and if acting for someone else, properly authorized. For example, a corporate officer signing on behalf of a corporation must have authority granted by corporate resolution, and a person signing under a power of attorney must have a valid power of attorney in effect. Mutual consent, also called offer and acceptance or meeting of the minds, requires a clear offer and an unqualified acceptance. If the acceptance changes any of the terms, it is not an acceptance, but a counteroffer, and no contract is formed until that counteroffer is accepted. Valuable consideration must be exchanged. In real estate, this typically includes money, such as earnest money and the purchase price, and can also include promises to perform, such as the promise to vacate the property by closing or to deliver marketable title. Consideration must be real and measurable, not just love and affection. The contract's purpose must be legal. Agreements to commit crimes or to hide illegal activity are void. Finally, the contract must be entered voluntarily and in good faith. If one party signed under duress or as a result of fraud or misrepresentation, the contract may be voidable by that party. Additional requirements for real estate conveyance contracts. Contracts that convey an interest in real estate must meet additional requirements beyond the general contract elements. First, with limited exceptions, they must be in writing to be enforceable under the statute of frauds. Second, they must contain a legal description of the property that uniquely identifies the parcel. A street address is usually not sufficient by itself. The legal description may use lot and block, meets and bounds, or rectangular survey references. Third, they must be signed by the parties to be bound. In many states, the seller's signature is required to convey title, and sometimes the buyer's signature is required in order to enforce the buyer's obligations. Short-term leases of 1 year or less are often an exception and may be enforceable even if oral. But as a best practice, many brokers still use written lease forms for clarity and risk management. Enforcement limitations, statute of limitations, and statute of frauds. Even if a contract appears valid, legal rules can limit enforcement. The statute of limitations restricts the time during which an injured party can file suit to enforce or rescind a contract. Once this period expires, the claim is barred, regardless of its original merits. This is why parties must act promptly when they discover a breach or a ground for rescission. The statute of frauds, as discussed earlier, requires that certain contracts be in writing to be enforceable. including most contracts to buy, sell, or long-term lease real estate. Listing agreements and property management agreements also must be in writing in many states. Importantly, the statute of frauds affects enforceability, not validity. If an unwritten agreement has been fully performed, parties generally cannot use the statute of frauds to undo what they have already done voluntarily. Review summary. In this section, you learn that contract law is the foundation for all real estate agreements. A contract is a meeting of the minds between two or more parties who agree to perform or refrain from performing certain acts. Courts classify contracts into four main categories: valid, void, voidable, and unenforceable. A valid contract contains all the essential elements and is binding and enforceable. A void contract is missing an essential element or has an illegal purpose and is not a contract at all. A voidable contract appears valid but may be rescinded by a party who acted under disability, such as fraud, duress, or lack of capacity. An unenforceable contract may satisfy the elements of an agreement but cannot be enforced because it fails writing requirements or has become stale through delay. You examine the essential elements of a valid contract: competent parties, mutual consent, valuable consideration, legal purpose, and voluntary, good faith action. You learned that real estate contracts conveying interest in land must also be in writing, contain a legal description, and be signed by the parties to be bound, with short-term leases often an exception. You saw how the statute of limitations and the statute of frauds limit enforcement rights and why parties must act within legal timeframes. Together, these concepts help you evaluate whether a real estate agreement is likely to be legally effective and what risks may exist if elements are missing or enforcement periods are ignored. Discussion. Why is it important for a real estate professional to distinguish between a void contract and a voidable contract in a transaction? Suggested answer. A void contract is legally nothing, so neither party can enforce it, and it cannot be fixed by later performance. A voidable contract, however, is valid unless and until the protected party chooses to rescind. In a transaction, this means that if a contract is voidable due to fraud or lack of capacity, there is still a risk that the protected party could back out later, unless the issue is resolved. Knowing the difference helps the professional advise clients to seek legal counsel, correct defects, or negotiate solutions before investing further time and money. How does the statute of frauds affect the way you handle agreements between buyers and sellers? Suggested answer. Because the statute of frauds requires most real estate contracts to be in writing to be enforceable, a real estate professional should insist that offers, acceptances, counteroffers, and major terms be documented in writing and signed. Relying on oral promises or handshake deals can leave clients without legal recourse if the other party refuses to perform. The statute of frauds therefore pushes the professional toward careful documentation of all essential terms. Closing remarks. Understanding contract validity is a key step in becoming a competent real estate professional. You now have a framework for recognizing when an agreement is legally binding, when it is nothing at all, when it can be rescinded by a protected party, and when it might be valid in theory but unenforceable in court. As you move deeper into real estate contracts, purchase agreements, listings, leases, options, and financing documents, you will see these concepts reappear. Each form you use is simply a specific application of the same general contract principles. The better you understand those principles, the more effectively you can protect your clients, manage risk, and keep transactions on track from first offer to successful closing.